Welcome again to today's webinar, Forced Arbitration, Workers and Marginalized Communities. I'm Minor Sinclair, Executive Director of the Center for Progressive Reform. We're pleased to co-sponsor this event with the Worker Rights Institute of Georgetown. They're an amazing organization that uses legal and policy initiatives to raise worker standards and build worker power. Our group, the Center for Progressive Reform, is a research and advocacy organization that harnesses the power of law and public policy to create a responsive government, a healthy environment, and a just society. The practice of forced arbitration could not be more pernicious. It denies access to the courts and formal justice for workers and consumers alike. By 2024, forced arbitration will cover 80% of all private non-unionized workers. And this topic could not be more timely. Last week, Congress passed legislation titled Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act by an overwhelming margin, which means that victims of assault and harassment in the workplace will be silenced no longer. Last Wednesday, our organization, the Center for Progressive Reform, issued a report on forced arbitration. Private Courts and Biased Outcomes was its title. And you'll hear more about this in the session. So I'm excited to introduce my colleague, Isabel Chowdhury, who will moderate today's panel and introduce our esteemed panelists. Isabel, over to you.
Thank you, Minor. So today we have 4 panelists joining us for this conversation. And I'll introduce each one of them and then get into the questions. So we have Mark Gaston-Pierce, former chair of the National Labor Relations Board and visiting professor and executive director of the Workers' Rights Institute at Georgetown University Law Center. We also have Jamila Bowman-Williams, associate professor of law and faculty director of the Workers' Rights Institute at Georgetown University Law Center. Sid Shapiro, Frank U. Fletcher Chair in Law at Wake Forest University and Vice President of the Center for Progressive Reform, and Jennifer Abruzzo, General Counsel of the National Labor Relations Board. So thank you all for joining us. I'll get started with Jennifer's questions, and I just want to note that the last 15 minutes or so will be dedicated to questions from participants. So I'll cut us off at around 4 o'clock. So my first question is for Jennifer, and I would like to discuss collective action. So collective action mechanisms allow individuals to band together to hold corporations accountable for unlawful actions, which make it worthwhile for attorneys to take on class actions on a contingent fee basis, even if members of the class have suffered only limited damages. Yet the United States Supreme Court has allowed a corporation to prevent consumers and workers from joining together in collective or class actions to pursue common claims against a company. Would you discuss the interplay between the NLRA and the Supreme Court's position about forced arbitration agreements and provide your thoughts as to whether workers are at a disadvantage by not having the opportunity to band together?
Sure. So thanks for having me. I thought to just give just a broad sort of primer on how the NLRA got enacted and why. And it was enacted during the Depression, and Congress enacted it to minimize industrial strife by equalizing the bargaining power between employees and their employers in order to protect employees' full freedom of association. So in my mind, our congressional mandate is to protect the rights of workers to unionize and collectively bargain if they so choose, but we also protect the rights of workers to stand together and to act collectively for the purpose of mutual aid or protection in seeking to improve their lot as employees. And it's unlawful to interfere with or restrain or coerce employees in the exercise of these rights. Yet, as you said, Isabel, Many employers require employees to accept as a condition of employment arbitration agreements that mandate individual arbitration of all work-related legal claims. So not only are the employers limiting the forum to only an arbitral one, as opposed to the courts, but more importantly for our statutory purposes, they're precluding collective activity by employees in the arbitral forum when a dispute arises. And employers defended these agreements by invoking the Federal Arbitration Act, which Congress enacted back in 1925 to overcome, at that point, the court's hostility to arbitration and put arbitration agreements on equal footing with other contracts. And then the courts had to enforce those arbitration agreements as written, subject to certain defenses such as fraud, duress, or unconscionability. Now, we fought against that sort of defense, and much to our dismay and disagreement, the Supreme Court bought into this employer's argument in Epic Systems and Murphy Oil and found that, these mandatory arbitration agreements are consistent with the FAA and don't run afoul of our statute. So just let me start by saying we recognize that arbitration is an effective forum to vindicate workers' rights. We've seen unionized employees who successfully utilize grievance arbitration provisions in collective bargaining agreements when they feel that they've been unfairly treated. Workers grieve the matter, and if they can't get resolution through union management discourse, then they can go to an arbitrator to make a final and binding decision. I'll also say that the NLRB remains neutral with respect to the forum used to address workplace issues. So that means that an employer requiring arbitration instead of court claims could be okay. But our big problem is that these agreements ban employees from bringing claims about workplace disputes collectively in any forum. They preclude folks from going to the courts, and they preclude folks from engaging together in the arbitral forum. And that's our major problem. So this allowance of mandated secret individual dispute resolution systems diminishes the collective rights that all employees have. It permanently removes employees one by one from the group available to engage in concerted activity to improve their workplace conditions and, to join a concerted lawsuit or to join in an arbitration either as a witness or more, in a more concerted fashion. So, respectfully, I just think the Supreme Court got it wrong. I think I know employees have a statutory right to pursue collective action. They're being required to sign away that right as a condition of employment. In my mind, the Supreme Court is promoting a contract of adhesion where all the power is in the hands of the employer who designed and mandate the arbitration process, and the employees who are under duress because they need a job have no real choice but to waive prospectively before a dispute even arises their statutory rights to engage with one another to address a workplace issue when it comes up. So in essence, the Supreme Court's allowing employers to use private contracts to evade their federal statutory obligations and pretty much has eviscerated public rights that Congress put in the NLRA. I will say that prospective waivers of statutory rights deprive employees of the opportunity to decide when an issue arises, whether to proceed alone, which they're entitled to do, or whether to initiate and join in a concerted response. And the worker should get to weigh the cost and benefits and may opt for individual arbitration, but they may also opt to pursue their grievances concertedly, believing, as we know, that there's strength in numbers, but that's no longer available to them in the individual arbitration scheme that employers are mandating. And relatedly, I'd say employees before courts that have authority to determine their legal rights may also find comfort and support from standing together as parties rather than appearing alone. So this divide and conquer approach fostered by these waivers in arbitration agreements really unlawfully deprive employees of the choice in terms of whether they should act collectively or whether they want to just, for whatever reasons, act on an individual basis. And just as an aside, I would note that the availability, whether pursued or not, of collective legal action can often steer workers away from engaging in more disruptive activity like strikes or work stoppages. So by interpreting Section 7 to protect employees who engage in a work stoppage to protest, for example, gender discrimination at the workplace, but not to protect those same employees by allowing them to maintain a concerted lawsuit under Title 7, it undermines Congress's goal of enacting the NLRA to minimize economic disruption. So I think the only solution here, and then I'll stop, is to say, I think Congress needs to act, as Minor said earlier, they have. They've, kind of done so in a limited fashion. But Congress needs to address the inconsistency between the Supreme Court's decision and the NLRB's congressional mandate. And frankly, they could look no further than the PRO Act, the Protecting the Right to Organize Act, which would ban these mandatory arbitration agreements broadly. So I'll stop there.
Oh, thank you. That was very comprehensive answer to the question. I was going to get into the next question, which is discussing the dichotomy between the process of choosing an arbitrator in a unionized setting where a collective bargaining agreement controls, and in a non-unionized setting when a mandatory arbitration agreement is in effect.
Yeah, so I mean, I'm sorry, so what I would say there is that in a situation where you have a unionized setting and you have a grievance arbitration process in a collective bargaining agreement, the grievance arbitration process is spelled out. And typically it includes, for example, that each side one or the other will go to AAA or wherever to get a panel of arbitrators, and then they have the opportunity to strike arbitrators that they think may or may not be who they believe might not be on their side, or who have issued decisions that may be more favorable to employers or workers on the other side of it. And so, but there's a mechanism, there's a process, and there's a way to weed out arbitrators that the parties feel may not be issuing decisions in the best interests of either management or the worker. In the non-unionized setting, as I said earlier, you don't have that. This is an employer mandated process, and the employer gets to decide who's going to arbitrate that. And frankly, I mean, there may be arbitrators in this audience, and I don't mean to say anything negative, but certainly if an arbitrator is getting paid by an employer, there could be, I'm not sure there's a true balance there in terms of being able to weigh all of the interests and making a real, truly informed and neutral choice. I mean, there are many great arbitrators out there. I just think that the deck is stacked against workers in situations where there's not this process such as there is in a unionized setting, and employees are basically at the whim of their employer's mandates and processes.
Thank you. You mentioned some really good points. I mean, we will get into some of the legislative fixes a little bit later in the discussion. I want to pivot over to discussing the populations who are most impacted by this issue, one of which are vulnerable communities and marginalized communities. I have another question for you, but I want to get to all the panelists, so I may circle back. But thank you for that really detailed, comprehensive explanation. So I'll switch over to Sid. I have a few questions for you. As I mentioned, we should get into some of the populations that are most impacted. And we recently, as Minor mentioned, published a report on this topic. So in general, for several reasons, the process of arbitration is inherently unfair and favors employers and businesses over employees and consumers. Forced arbitration makes it far easier for corporations to steal a single dollar from 1 million people than it would be to steal $1 million from a single person. And we kind of went over that with the issue of employees and consumers being able to come together. So in an extensive study of forced arbitration, the CFPB found that almost no consumers filed arbitrations about disputes under $1,000 to dispute an action by banks, credit card corporations, and other lenders. Sid, can you give an overview of this issue and specifically highlight what really makes arbitration unfair?
Thanks, Isabel. Well, to pick up on Jennifer's comment, what makes arbitration unfair is workers don't have an equal say in designing the system. So as we heard in unionized workplaces, arbitration can work quite well. And that's because the workers who are collectively organized have the bargaining power to say, this may be a good alternative for us. But we want to make sure it actually is a good alternative. By comparison, outside of that context in consumer contracts or in most employment contracts, because they're not unionized, the company itself has an oversized influence in the design of the system. So the way the system works is it develops these trends which tend to make the corporation either not accountable at all, it just immunizes the corporation. Your example of stealing $1 from 1 million people is a good example of that. Or it just generally works in a way that disadvantages consumers. So consider, and again, picking up on Jennifer said, there are arbitrators and there are arbitrators. And what we're talking about here is trends that are overall. It doesn't describe every individual arbitrator. But if folks are dubious about what I'm about to say, they ought to consult our report, because there's a very deep literature. There's lots of empirical information backing up the disadvantages of consumers as I'm about to enumerate them, and people can check our report to consider that. First of all, it is the companies themselves that choose the arbitration firm. So from the get-go, the company is in the leading edge of designing the system. And when a consumer or an employee finally says, I need to dispute this, they're stuck with the company that the arbitration firm the company has chosen. So there's no competition, to be fair to both consumers and the company, right? Because consumers themselves are not doing any of the choosing. So you can tilt your system, or at least not have safeguards in your system to protect consumers. And it doesn't really matter because we're not choosing. It's the company that's choosing. Second, there's information showing that arbitrators have a potential bias, because if you start deciding a lot of decisions against the company, they could just choose a different arbitrator. So you have to carry around in the back of your head, this is a good gig, but it may end very soon if I issue a series of decisions favoring companies. Third, very few of these agreements require arbitrators to follow the rules of evidence. If you were in court, the lawyers have to follow the rules of evidence. The judge has to follow the rules of evidence. Arbitrators don't. Arbitrators are not required to write a written opinion. Some do. Some agreements require that. Many do not. So there's no written justification which says, here's how I came to this decision, and I have a way of defending it based on the law and facts. Just doesn't happen. Because there's no written decision, arbitrators don't have to apply the law consistently. When you go into the court system, there's something called precedent. A judge has to defend his or her decision based on prior decisions. In light of what we decided previously, here is why what I did is justified. Arbitrators don't have to do that. Arbitrators aren't subject to judicial review except for very narrow circumstances. So they can't be overruled. If you can't be overruled, you're more likely to be arbitrary. And then finally, as Jennifer well explained, individuals can engage in class actions, which means they probably won't use the arbitration system at all because their individual claims doesn't justify hiring a lawyer. If they could act collectively, and there are hundreds of people involved, then a lawyer has a financial reason to get involved.
Thanks, Sid. So these points are mentioned in the recent CPR arbitration report that was published last week. Also mentioned in the report, you highlight that consumers and employee advocates, journalists, and academics have shown how forced arbitration makes it more difficult and often impossible for consumers and workers to hold corporations accountable for their illegal behavior. But what has not been sufficiently recognized is the impact on low-income Americans, people of color, women, and abused and injured nursing home residents. So forced arbitration impacts these historically marginalized communities, and particularly the victims of systemic discrimination, in ways that go beyond general adverse impacts. Can you discuss who are the historically marginalized groups? I named some of them, and how these groups are disproportionately impacted by forced arbitration?
I can. And as you said, that's the news of our report. We are among many who've recognized that forced arbitration is generally unfair to individuals and favors corporations. We're not the first to say that. That's why I said there's plenty of evidence to back up what we said. But what people haven't noticed in the same way with sufficient attention is that it has a disparate impact, a greater impact on marginalized communities. So take, for example, low-income individuals. So as I mentioned earlier, people are unlikely to file claims. If they file claims, they're not very likely to win them. And if you're low income, the effect of not getting justice is even greater on you because you can't afford the lack of justice. You're really stuck with whatever situation you were put in. Secondly, under most arbitration agreements, the individual has to pay some of the costs, and they can be quite high. If you litigate in court, courts charge a filing fee. It's very modest, and arbitration fees can run into the hundreds and thousands of dollars you have to pay for the arbitrator. Again, low-income people are hardly in a position to do that. And then finally, as we've discussed before, you can't aggregate your claim with other low-income people, put a bunch of people together, say, we have a real claim. This corporation really is probably acting illegally or stealing our money. And a contingent fee lawyer will say, I'll take that case on because it's on behalf of lots of people, and I can get justice for all of them at the same time. It's particularly disadvantageous for low-income people. Let me give you one more example. Let's look at workers who are low income or people of color who are low income. There's pretty good statistics that if you are a low income person or a person of color, you're more likely to be subjected to forced arbitration than other workers. You're also much more likely to be the victims of wage theft. So you put those two things together, you don't really have good access to justice. You can't really afford the losses. You're much more likely to be the victim of wage theft, and you can't afford the losses after they occur. So we go through other examples in the book, but all of them really show the same thing, that in marginalized communities, you are especially disadvantaged by this tendency of the system to work against individuals.
Thank you, Sid. I have another question about possible legislative fixes on this issue. I know Jennifer briefly mentioned the PRO Act. Could you discuss other possible legislative fixes? We also had the passage of the Ending Forced Arbitration for Sexual Assault and Sexual Harassment Act that passed last week.
Yeah, I mean, there's another, I don't know who you were addressing that to, but there's
Oh, either
another.
one of.
Oh, okay. I just say there's another one, a similar PRO Act, but it's more related to public employees because the NLRA doesn't cover private sector, only covers private sector. So, but I'll leave it to others to talk about what other legislative fixes they may think.
Well, the CPR report does that, so I can. So the deal is Congress did fix one area, which are the victims of sexual harassment, and goodness knows that's important. But that leaves the rest of us still in forced arbitration, and there are millions of us left in the system that they didn't address. And it's really hard to understand this. If it's unfair, forced arbitration is unfair to the victims of sexual harassment, and it is. How's it fair to the rest of us? The same reasons why you wouldn't let a corporation force arbitration on the victims of sexual harassment argue for the same result when it comes to the rest of us. So at CPR, we simply take the position Congress ought to end forced arbitration, period. And they ought to end the ban on class actions of individuals getting together. And they ought to make it clear that the NLRB Act that allows collective action by employees who aren't unionized is good law once again, and is not overruled by the Arbitration Act.
Thank you. I want to just pause briefly to let folks who just joined us know that you can ask questions in the question Q&A box at the bottom right-hand corner. And I'll reserve the last 10 or 15 minutes for questions so the panelists can address them. So moving forward, I have a few questions for Mark. I want to circle back to class actions, which would allow historically marginalized communities to effectively hold corporations accountable for widespread discrimination and other harms. Could you address how these groups are disproportionately impacted by not having the benefit of banding together? I know Jennifer sort of briefly went over that as well, but can you get a little deeper into that issue?
Unmute yourself, Mark.
Yeah, I see I'm muted. I say my best stuff when I'm muted. Thank you, Isabel, and thanks everybody for joining in this great discussion. I want to first state something in response to Sid's excellent presentation, and that is I agree for the most part with Sid, well, in many respects, except that I'm not ready to throw out the baby with the bathwater. Arbitration does have its value, but particularly in settings, unionized settings, where unlike individual settings, arbitration is working in conjunction with the collective power of organized labor. As Sid says, in forced arbitration scenarios, you usually have situations where the claimant or grievant really does not have too much say-so in the arbitration process. In collective bargaining with organized labor, there is a little bit more say-so in that regard. So much so that, as Jennifer could tell you, the NLRB even is willing to cede responsibility of enforcement of the act over to arbitrators on occasion through the deferral process. Now, and then of course, litigation is not always the walk in the park that we think might be the great alternative, because of course, You have to lawyer up. There's no contingency fees in a lot of employment cases. I did employment law for a while. In some cases, the lawyers are saying, well, you know, this is a tough case, so we're going to have, we can't do this on a contingency basis because there's no guarantees. If there's discovery, there's a lot of expenses that are going into that. And most assuredly, an employer is going to file a summary judgment motion, something that you don't see in an arbitration process. And that involves a lot of intense work on the part of litigators to respond, and that's going to cost. Now, back to your question, Isabel, by way of background, the Supreme Court in the Gilmer versus Interstate Johnson case way back in 1991 upheld the use of mandatory arbitration agreements in federal age discrimination claims. That was the first shot across the bow. They carved out employment contracts from such mandates, but 10 years later in Circuit City, the Supreme Court narrowed the FAA's exemption to only apply to employment contracts involving transportation workers. The consequences of these decisions, as well as the Supreme Court's decision in Epic System, which, as many of you know, holds that the legality of making a class action or group grievance waiver a condition of employment was okay, created a situation where there's a proliferation of mandatory arbitration agreements with class action waivers. The disproportionate impact of these decisions comes in several ways. High-level hires have the advantage. They have cachet. They have the ability to leverage or to negotiate more favorable terms to their employment agreement, which may either offset the mandatory arbitration clause or effectively neutralize it, because the employer wants that individual and is willing to bargain for that individual. Workers hired at low-level, low-wage jobs, the category with the highest percentage of immigrant and people of color, do not have that cachet. Yet, and still most low-wage workers, women, and workers of color are subjected to mandatory arbitrations in some form. As your report shows, and as statistics show, 64.5% of workers making less than $13 an hour are subject to mandatory arbitration, as well as 57.6% of women workers, 59.1% of African-American workers, and 54.1% of Hispanic workers. Employment contracts, though touted to be bilateral in terms, as Sid indicates, are really unilaterally imposed conditions of employment presented on a take it or leave it basis. Moreover, high-level executive compensation disputes will be pursued whether individual or in a class because the dollar sign is right. But if you got a dispute over a few $1,000s by an individual, it's very difficult, near to impossible, to get a lawyer to take that case, particularly if the lawyer cannot couple that case up with several other cases that would make for a decent piece of litigation. And the insult to injury is that that case cannot even, the grievant in that case cannot even utilize other like affected grievance to assist in this process, because a lot of these arbitration clauses don't permit sharing that information with others or joining or aiding others in their similarly situated litigations. Now, as was mentioned, employers tend to win cases more often when they appear in front of the same arbitrator in multiple cases. And that, of course, gives them a clear advantage. And arbitrators that have issued too many awards, as has been pointed out, that are favoring claimants don't get picked again. The challenge, though, is that we are in a litigious system, and there has to be a balance struck. I celebrate this new bit of legislation because there needs to be a carve out for a lot that impacts low-wage workers. The question becomes, will the ability to litigate disputes be a viable alternative for these low-wage workers in all cases?
Thank you for providing that explanation. It's clear that there are many barriers to disproportionately impacted groups being able to band together. And I want to pivot over, well, actually, before I get into that, I just want to clarify that we are not against arbitration in unionized workplaces. In case it may have appeared that way in the way I may have asked a question, or if, based on something one of the panelists may have said, but that's noted in our arbitration report. So just wanted to point that out. So I want to talk a little bit about some of the implicit bias and discrimination in arbitration. And I know you have a lot of expertise on this, Mark. Data collected from two of the largest arbitration firms indicate that among arbitrators, women and people of color are underrepresented in or relative to the population of the country and relative to the population of American lawyers and judges. While there is significant underrepresentation for both groups, it's important, or it's more important for women of color than, or more significant, I should say, for women of color than female arbitrators. As well, arbitrators are more likely to be the victims of implicit bias and discrimination because almost all arbitrators are white males. So how does this lack of arbitrators of color impact claimants? And have we seen specific examples of these impacts?
Oh, we certainly have. The impact is substantial. According to the American Association for Justice, about 88% of arbitrators with the American Arbitration Association are Caucasian. 3.9% are African American, 3.7% are Latino, 1.5% are Asian American. Racial bias is significant. The lack of arbitrators of color could cause issues of implicit bias and discrimination to fester in practice, whether it be conscious or unconscious. Language barriers for various non-English speaking workers, the lack of arbitrators who speak their native language creates issues with respect to the ability to get credible testimony or to be perceived credibly by a forum that is making a significant decision on a case. Arbitrators are judge and jury. In a court, one is expected to be judged by a jury of one's peers. While that doesn't always work out, with 88% of arbitrators being Caucasian, I submit that there is a greater likelihood that a person of color is going to get someone of their ethnicity or race in a jury pool than they will among the arbitrators being selected. Additionally, well, let me give you a famous example, one that everybody's heard about, and that's the 2018 issue with Jay-Z, where he sought a temporary restraining order to stop contractual proceedings before the AAA because there were not enough African-American candidates in the pool of arbitrators to make the panel. Jay-Z alleged that the AAA provided only 3 African-American arbitrators out of 200 who were qualified to participate on the panel for this contractual dispute, which left him with no choice, according to his arguments. And therefore, it was discrimination based on race and a violation of New York's Equal Protection Clause. And that was the basis for this TRO. Now, these allegations were enough to catch the attention of AAA, so much so that AAA agreed to use a 3-arbitrator panel instead of a single arbitrator and offered 5 additional African-American candidates to be considered for the panel. They agreed to consider a list of 11 African-American candidates to add to its greater pool of arbitrators to handle the big arbitrations. On those terms, Jay-Z said, okay, I'm satisfied, and he was able to settle the suit subsequently. Now, in the wake of Jay-Z's negative press, affirmative steps have been taken by AAA and FMCS to ensure more diversity in arbitration panels, such as more intense recruitment and something akin to the Rooney Rule in the NFL, where every arbitration panel offered for party selections must have at least 1 diverse candidate. But breaking news, we see what's happening with the Rooney Rule. And if we take a look at former Dolphins coach Brian Flores and the Miami Dolphins, that illustrates providing 1 diverse candidate does not guarantee fairness in the selection process. Moreover, the average grievance of color does not have the clout of Jay-Z. Most corporations, for corporations, typical arbitrator selection is like jury selection in the real world. And that is, the difference is corporations have unlimited preemptory challenges. If the claimant is of color or a woman, the employer is not likely to agree to an arbitrator of color or a woman. Should one or the other exist even in the arbitration pool, on the theory that the arbitrator cannot be neutral. Needless to say, women arbitrators of colors have two hurdles if we have either a woman or somebody of color as a grievant. A study by arbitrator in Howard University, Professor Homer LaRue, reveals that when only 1 diverse person in the pool of finalists exists, the difference between the one and the norm is highlighted. The translation to the advocate selector is that deviation from the norm or status quo is risky. So what do? They select who they know. And who do they know? It's usually male, senior, and white individuals. Professor LaRue has proposed that there be a higher percentage of diverse candidates in the pool and a statistical transparency in the selection process. And therefore, that pool of that percentage of selections would increase exponentially. I think he calls it the Ray corollary, but he's published about that and you can check it out.
Yeah, I read Professor LaRue's article, and it was very insightful. And I do agree that it's great that we had a celebrity point this issue out. I remember when I saw the reports and the articles in the news about Jay-Z pointing out this issue. I want to talk a little bit about how these specific groups, the vulnerable communities that we've been discussing, are impacted in the workplace, specifically with discrimination. And as we've shown there are a lot of barriers from the process of arbitration to, the preclusion of these groups being able to band together, to the actual issue with diversity within arbitrators. Can we talk a little bit about how this looks like within the workplace? I want to pivot over to Jamila and ask the question. So my question is, within the workplace, women and people of color are more likely to be subject to workplace discrimination than their white and male counterparts. Can you expound on the issue of workplace discrimination and forced arbitration?
Sure. Thanks for having me again. As everyone else has said, this has been a great discussion so far. And I'm glad to be here to talk about this issue. So I'm going to talk about arbitration specifically related to workplace civil rights claims and how that's been particularly problematic for these marginalized communities we're talking about. So workers of color, often immigrant workers, women who've been sexually harassed. So thinking of workplace discrimination and harassment, the victims do typically come from these groups. So Black people, Latino workers, again, commonly immigrants. So under Title VII of the Civil Rights Act of 1964, it's an unwaivable statutory right to be free from workplace discrimination and harassment. But we have seen that discrimination and harassment in these really what's often emerging in many contexts is a toxic workplace environment. It's become a norm for many workers. Okay, so the Me Too movement really brought the issue of workplace harassment to the forefront. The EEOC has found that nearly 70% of women have faced workplace harassment. Research has also found that women of color face the highest rates of harassment for a variety of reasons. Many of them have been discussed already, just being overrepresented in the low-wage jobs and some of the industries where harassment is just prevalent and pervasive. Many of them end up being in our frontline jobs. So those who have really been carrying us through this COVID-19 pandemic. So workers like those in food service and manufacturing, retail, janitorial workers as well. All right, so these really are vulnerable workers, but despite the vulnerability and the prevalence, we're really seeing many of these claims being forced into private arbitration. So there's no recourse in court, as we've talked about really extensively already today. We don't have access to the justice system really as Title VII was designed and structured. Okay, so then when you're being pushed out of court and being forced into mandatory arbitration, really all of the issues that have been discussed thus far are going to limit access to justice there. So we've already talked about the largely secret process. Employer sets the terms. There, you actually, if you're experiencing harassment, think about then you're facing your perpetrator within that private context, right? So there's less protection and less trust in that process for many of the reasons that have already been discussed and that are in your report. As Jennifer and Mark already talked about as well, these class action waivers are very problematic for these civil rights, these discrimination and harassment claims as well. All right, when they have to be brought individually, when many times there are multiple victims, many victims of things, when we're thinking about systemic racism and sexism and those types of abuse that arise in the workplace. All right, this quite hasn't been mentioned though about the difficulty not only of gaining access to court, but also getting representation, right? So when you're really required to do it on your own, damages could be lower, maybe the facts aren't as broad, you don't have as much information when it's in silos. So that's gonna affect whether you're able to get an attorney to take on your claim. And plaintiffs' attorneys are well aware of these barriers and challenges that we've discussed, all right? So as much as they may wanna help someone facing these types of violations, it's tough and tricky for them when they're going to arbitration, okay? And then, of course, when you can bring people together, it's a more powerful legal claim, all right? So really these factors are really silencing workers in many unjust ways. And more importantly, I guess more specific to me, and what in this concept of discrimination and this area of discrimination harassment, it's undermining the core purpose of the civil rights law, right? So yes, we're honoring the FAA, but then we're undermining what Title VII says it will do, which is to rid workplaces of unlawful discrimination and harassment. So really, Mark just mentioned this is going to reinforce employer abuse in many ways. It's not going to incentivize them to change their workplace practices and policies, culture, in order to create an environment where harassment and discrimination is no longer tolerated. So yes, now we have new legislation now on the horizon that will require workers, that will not enforce these clauses that require workers to arbitrate their sexual harassment claims and sexual abuse claims. But then, while this is a major development and it'll help with this troubling trend that we're bringing to light and having this conversation about, I still am a little bit hesitant in celebrating the progress so much because it can be limited. It just depends on how it ends up being interpreted. It can still leave a lot of gaps for these marginalized groups. And Sid talked about wage theft. We have racial harassment. We have other types of discrimination and abuse. So really, those are also civil rights violations. And who are we to say that, this is so problematic, we shouldn't require this for the sexual harassment, but these other types of harassment, then you're still stuck in arbitration, right? So then we have to step back and question, does that really make sense? And are we okay with that as an outcome? So that's just my little preliminary thoughts as well on that bill too. And it'll just be interesting to think about. I think as Minor mentioned it as an outset, he said that 80% of the private sector non-union workers will be bound by the mandatory arbitration by 2024. So just with the legislative developments, it'll be interesting to see what happens with that trend from this part. A lot of this is just an empirical question. We're gonna have to sit back and watch how this all plays out.
No, thank you. Those are very huge points. And I agree. And we had this conversation about the issue of possibly, piecemealing this issue. There are various forms of discrimination that should be addressed. And hopefully legislation will be interpreted more broadly to address and provide relief for these impacted groups. I want to touch a little bit on something that we hadn't discussed, but is a big issue in arbitration. Because arbitration awards are private, it's difficult to gather data and studies on specific instances of atrocious acts, as you just alluded to. Could you discuss how the issue of transparency and privacy of arbitration impacts victims and claimants?
Yes, sure. So that is a big issue. So we've already talked about how arbitration requires this private process. Really, the lack of transparency is going to lead to a big accountability issue, right? So when we have a federal law and we have government agencies here to enforce it and all of this, the idea is that there should be some public accountability for this type of illegal action. But right now, we're not seeing that. It's happening behind closed doors, and then there isn't broader awareness about the frequency of these harms, which employers are committing the harms, which industries, which, where is this happening and what are the outcomes? Really, there's a big legal scholar, Cynthia Esplin, talks about this being this big legal black hole, right? So we don't have the precedents from developing as well. So Sid mentioned, really, how are these even being analyzed? We don't know. So that's going to create major accountability issues if we don't have data on these things. We don't know how they're coming out. And then this is also going to exacerbate the information asymmetry that already exists between workers and employers. Okay, so they don't know. This really touches back on the collective issue too. They don't know when other workers have the same grievances or are suffering the same thing, or how courts are coming out on those. So really we don't have a chance to share that information in a way that really could start putting the end to some of this illegal discrimination and harassment. Another thing with the privacy, I guess it goes back to that kind of information asymmetry and lack of awareness. Really, you can't then determine when something is systemic. So I guess they're the egregious. You don't know when something egregious is happening, like you said, but also when there's a pattern and practice of it in many places, we don't know that, right? That's a problem for both employers and employees, because employers, maybe they have a little bit more of an idea of this, but maybe not, particularly if many claims are falling through the cracks because they aren't even brought because of the arbitration barrier. So anyways, the patterns and systemic issues of racism and sexism, I think, will persist more with this type of system and without having the transparency and accountability that we need.
Okay, thank you for also addressing that. We've talked a lot about, the issues with arbitration, and I've tried to provide through the questions in this discussion a sort of comprehensive view of how, deep this issue is. But I want to bring some light to this discussion a little bit and talk a little bit about how have employers taken steps to address the issue in absence of policy solutions. So this question is for you, Jamila, but also I'll open the question up to the other panelists and ask, are there other legal avenues advocates can seek to address the issue of forced arbitration?
So I'll get started with that. And we've talked mainly about federal policy. So I'll talk a little bit. I saw a question about state policy as well. But yes, employers have made some changes, but it hasn't just been voluntary without any pressure. It's because employees are making a big fuss and walking out and coming together collectively, really to pressure them and to come together on their with their collective grievances, but not necessarily through the court system. So things like strikes and walkouts have been very, very effective with this. So we see workers, there was just the recent case that Activision Blizzard, the video game studio, where there was a walkout with the sexual discrimination and harassment suit. So they demanded the end of arbitration. The Google workers demanded the end of arbitration. And their employers have been making some changes based on that. And then other companies have looked at that. Facebook, Airbnb have looked and then followed suit with getting rid of arbitration, forced arbitration. Often though, that can be limited, again, just going back to my prior point, with respect to the specific issue that they're bringing up. Sexual harassment, will end it for sexual harassment, but maybe the, compensation discrimination and the pay gap, and then the racial harassment and the wage theft, no, we're not going to change it for that. So that's, so that is a change of, but some of the gaps still there. We're also seeing trends with mass arbitration. So that's where there are workers at companies who are coming together, and they're really doing large numbers of arbitration. So we can't bring them as a class. We can't bring them collectively in one suit, but we can bring many many, which makes it difficult for the employers to respond to. It's costly, and that also creates pressure. Okay, do we really want to keep these silo claims if we're facing this many of them? Maybe it's better to just face them in a class. So that's another trend. And then you have the state legislation. So that was a response we saw after the Me Too movement, where there were a number of bills introduced at the state level. Again, most of them were geared towards ending forced arbitration for sexual harassment claims. Only a couple of them passed in a few states, but then there's also the preemption question, right? So then, New York, New Jersey, Maryland, if they pass something to end forced arbitration for sexual harassment, is that preempted by the FAA, which says that we should, interpret it broadly in favor of arbitration. And that's why the federal law becomes important in that context. And just going back, I just don't want us to forget about, if we're really talking about marginalized workers, if we're looking at a woman of color who is facing sexual harassment and racial harassment and wage theft, really, are we going to interpret it in a way that's going to encompass all of those, where none of those claims have to be forced into arbitration? So that's really what I want to kind of come back to. The same thing with the other employer changes, really many of the reforms on the different levels. We have to just kind of keep that in mind too. So I'm with Sid on the broader reforms, just to capture more if we really think that this is problematic.
Thank you. And again, any one of the panelists can continue to answer the question about, other legal avenues.
Well, I want to echo what Professor Bowman had said about some corporations having waved the white flag in response to a lot of heavy duty pushback by employees. It's also a product of what in unionized settings is called working to rule. I remember running into an attorney who was who was a management side attorney doing a defense work for employment litigation. And he says, well, I've changed firms. I'm now doing plaintiff side work. And I said, really, why would you do that, particularly in light of ethics systems and all of that stuff? He says, well, we have the resources to go against corporations and bring 50 to 100 to 150 to 200 claims separately. If they want to deal with it separately, we're going to bring separate claims until they wave the white flag, because in most of these agreements, the employer has to be willing to have to pay a large percentage of the fees, of otherwise being at risk of having the contract being considered an adhesion contract. And consequently, you have big corporations that have waved the white flags, like DoorDash, who has decided, we're not going to do this, like Facebook, as was mentioned, and a few others. So that response is a great one, but again, it's specific to those who have the horses to be able to apply that kind of pressure. The answer is going to have to be in the legislation. The PRO Act is a good example, because the PRO Act addresses these kind of concerns in terms of mass arbitration, and it would, if passed, adjust the FAA to allow for mass arbitration and to define collective bargaining in the concerted activity in the way that it was intended. That means group action for terms and conditions of employment and mutual aid and protection. As you know, right, Jennifer?
I don't know if Sid wanted to weigh in. I mean, I think that everything has been said, but I don't know if Sid, you want to anything more?
Well, I don't want to rain on the parade, but look at these examples. The Google workers, hundreds of them go on strike. Google gives in. The game company workers, these are high-paid workers. We don't see stories that the women who clean our rooms in hotels leave the hotel and march out front to demand an end to forced arbitration in their employment agreements. And there's a good reason for that. They're going to lose their jobs because they're unprotected and they can't afford to lose their jobs. So if we're going to protect them, we need to have legislation. Some workers will be successful in getting rid of this stuff. Some law firms will have the kind of resources that might solve 200 cases here, 300 cases there. But the estimates are there are 800 million forced arbitration agreements out there. There are only 300 million of us, and there are 800 million contracts. We're not going to get rid of 800 million contracts because a law firm can bring 100 cases here and 200 cases there. And most of those cover people who couldn't possibly act collectively without losing their jobs.
Thank you. Thank you, Sid. We have a few questions from participants, but I know we're short on time. So we have one question here, which I'll read out loud. Oh, that's a good question. Will there be a discussion of the Ending Forced Arbitration of Sexual Assault and Harassment Act? I know we mentioned it briefly, and also Jamila provided a really good critique about it, but does anyone have anything to say about the significance of the passage of this act?
Well, I read a statement made by Sarah Rudolph Cole, a law professor at Ohio State University who focuses on issues that arise from alternative dispute resolution. She said that the bill will cause companies to re-examine all mandatory arbitration agreements, but really, how do you justify sexual harassment not being arbitrable, but race harassment is? And that's going to be continue to be the elephant in the room. How are we going to carve out this little narrow exception without taking everything else that substantially affects poor people and people of color?
Yeah, and it's not only how, it's why, right? It's
Right.
I mean, the how is a little tricky even because it is narrow, and as Jamila pointed out, so if a woman of color has been sexually harassed, but she also has been subject to racial discrimination or wage theft, is the employer somehow going to say, well, those two latter things have to be, we're going to force you to arbitration for those two latter things, so you can only take the first thing, to court. So, the process is just, the devil's going to be in the details. Or is it going to be, well, if you've got one claim that falls under the act, then all claims could go to court as opposed to being forced through arbitration. But then the bigger question is just the why, which I think Sid mentioned also. It's like, how do you justify sexual harassment and assault, which is horrendous, clearly, but how is that any more egregious or horrendous than racial discrimination or gender discrimination or age discrimination or any other protected class discrimination?
Well, my thoughts on the why is pretty simple. There was bipartisan support for this legislation. If this legislation dealt with carving out race, you wouldn't have had bipartisan support.
Also, to get agreement and get the Republican senators on board, the legislation, rather than banning arbitration in non-unionized settings, it now requires the employer to give the employee the choice when she's about to file a claim, whether to arbitrate or take it to court. That's an improvement, no doubt. But I wonder in practice how that's going to work out for the groups of people we're talking about. Are they going to have a right to do this, but in effect, economically and socially, are they going to be bullied into arbitrating it anyway? How much influence is the employer going to have over that process when workers, by very definition, are marginalized and can't afford to lose the job and can't afford to lose the paycheck? So I just wonder, it's more protection than we have now, no doubt. But as to the people we're talking about in this particular webinar, I'm not sure that this is the answer. In fact, I think it isn't.
I'll just say one more thing on that note. We've been seeing so much employer intimidation and these types of tactics to keep employees from coming together, and even if they do have a right to do that. So I'm concerned about that as well, Sid. particularly if the employers know that this means that this can lead to a class claim, not an individual claim. Like, how is that going to be presented? Are they going to actually be able to assert that right? Or are they going to end up in arbitration anyway? So thanks for reminding us about that piece of the legislation.
And I would just say one other thing, as I said at the very beginning, an arbitral forum could be fine. It's the individual mandate that's the problem. If you can't act collectively, just choose when a dispute arises to decide whether you want to go it alone or act collectively. You don't have that choice. So regardless of court or arbitration, and the same, you can stop bans, but what you really need to do is, if you're going to say, well, we want arbitration as a forum, you need to stop the mandate for individual arbitration.
Very good point.
Yes, very good points from everyone. We have one more minute, so I will close us out. And again, I want to thank all of the participants who were able to join us today. This will be it is recorded, and it will be emailed out tomorrow. Hopefully, we'll be able to continue the discussion. Thank you again to all the panelists. Your expertise was very insightful and comprehensive. Thank you.